The Biden administration recently announced support for suspending COVID-19 vaccine patents of companies like Pfizer and Moderna to allow companies outside the United States and Europe to manufacture the drugs that they did not create. What should we think of these proposals, and what will be their impact on the development of life-saving vaccines? Well, welcome to New Ideal Live, the podcast of the Ayn Rand Institute. My name is Ben Baer. I'm a fellow at ARI. Joining me today to discuss the topic of the vaccines and how to evaluate this recent policy of proposed patent waivers is Professor Adam Mossoff. Adam Mossoff is professor of law at Antonin Scalia Law School at George Mason University. He's a senior fellow and chair of the Forum for Intellectual Property at the Hudson Institute, a visiting intellectual property fellow at the Heritage Foundation, and a member of the board of directors of the Center for Intellectual Property Understanding. He's published extensively on the theory and history of how patents and other intellectual property rights are property rights that should be legally secured to innovators and creators. His scholarship has been relied on by the Supreme Court, by other U.S. federal agencies, and he's been invited a number of times to testify before the U.S. Congress. His articles have appeared in such places as the Wall Street Journal, New York Times, Forbes, and other outlets. So welcome, Adam. We're happy to have you on today to discuss this very important issue.
Thanks, man. It's a real pleasure to be here.
So we should start, I think, by giving our audience a little bit of context about this issue and how it has developed in recent weeks. So as I understand it, there was speculation for a number of weeks about what position the Biden administration would take on the enforcement of patents internationally. The speculation came to an end on May 5th with a tweet from the U.S. trade representative, which I think we can put on screen, where the trade representative said the U.S. supports the waiver of IP protections on COVID-19 vaccines to help end the pandemic and will actively participate in WTO negotiations to make this happen. I should also mention, interestingly, that about a month ago, before this policy was actually announced, you, Adam, published an article in the Virginian Pilot, anticipating that this move might be made, but arguing that it would be unjust and that there would actually be there's no reason to think that it would actually help increase production of the vaccine, which is the justification cited for the policy. So you were somewhat prophetic in saying that this would be one of the most important decisions made on the subject. It did actually happen. Can you fill us in a little bit more on what exactly the administration is proposing to do with regard to patents? What's the role of the WTO here? And there's talk of something called the TRIPS waiver. Maybe you can fill us in on that too. And then we'll talk more about what you think of it. But what are the details of what's going to happen here?
Sure. That's a really great question, Ben. It's a little bit of a complex issue involving our international treaties and the obligations under our treaties to respect intellectual property and other countries' obligations as well. So this is all occurring at the World Trade Organization, the WTO, one of the organs of the United Nations, which has authority and governs kind of the negotiation of international treaties that pertain to economic issues, and intellectual property is one of those. And in 1994, many countries agreed to a treaty called TRIPS. It stands for Trade-Related Aspects of Intellectual Property Rights. And the purpose of TRIPS was to both kind of harmonize intellectual property protections throughout the world, given that products are sold globally now, but also to try to incentivize developing countries to provide for intellectual property protections themselves. And so it created a bunch of incentives, trade benefits and things of that sort for countries to enact patent laws and copyright laws if they didn't have them. But it also provided mechanisms for punishing them and sanctioning them if they did not at least protect TRIPS member countries' intellectual property rights, since intellectual property rights are secured under each country's laws. And it also provides a mechanism for filing complaints, a type of dispute resolution process for a country that is violating or not respecting the rights of other countries. And if they're found not to be, that they will then can have sanctions brought against them on those grounds. And so this is all occurring at the WTO. So the Biden administration's announcement is not about U.S. domestic patent law, or at least not yet. It's about the TRIPS agreement and whether there will be a wholesale waiver, a wholesale essentially nullification of TRIPS for all intellectual property rights that pertain to COVID vaccines, drugs, and other treatments.
And so then what is it that the Biden administration is proposing that the WTO do exactly with regard to these patents through this TRIPS waiver?
Yeah, that's a really great question, because the actual language hasn't even been proposed yet. So what happened is that India and South Africa proposed back in September to the World Trade Organization that there be a wholesale waiver of all intellectual property rights, especially patents, but includes other intellectual property rights. And I think we'll want to talk about that a little later, for all COVID-related treatments. And they've proposed these waivers before in other instances for AIDS treatments and things of this sort. And most people didn't expect it to go anywhere, because the G7 countries, which offer very strong protections for intellectual property rights generally, have always opposed these proposals in the past. And the WTO works on consensus, so you have to have every country agree to it. And so it's the extent that the United States consistently opposed these in the past, they didn't expect it to go anywhere. Now that actually the US has come out and supported it, which is unprecedented, has never happened before. The proponents for this waiver, and so India and South Africa specifically, but all of the academic supporters and so-called quote public interest unquote organizations that supported it, that they will now actually have to put together some language. What actually is this? Will be the content of this legal agreement that will bind all these countries that have agreed to TRIPS. And then each country will then have to implement the terms of that waiver in their own laws. And so this is just the start of a long process now, which will probably not conclude until what is expected to be in the fall, when the WTO will probably adopt the waiver as expected.
I know you said it's hard to answer questions about what exactly this is going to do, because there's not actually any language that's been agreed to yet. But what would you expect to come from it? Would you expect that they would agree for an indefinite waiver, or would they agree to it for a delimited period of time or something like that?
Those are some of the really interesting questions. And clearly, the Biden administration didn't think any of this through, and the proponents really haven't thought much of this through, largely because the proponents are not responding to the pandemic per se. So South Africa, India, and other countries that who pushed for this waiver have, as I mentioned, pushed for waivers in the past. So this is the same group of people who have always been fighting against and opposing intellectual property. So they're acting on Rahm Emanuel's very infamous declaration back in 2008, the start of the Great Recession. Right? Never let a good crisis go to waste. And so they just took advantage of this crisis as a way to attack intellectual property. So now that the U.S. has announced its support, the pharmaceutical industry, which opposed it, and other people such as myself and others that have been pointing out, have been identifying some of the difficulties and problems. And so there will be probably some negotiations over the scope of this. But the idea, if you were maybe to have a kind of a rough guess, is that they will probably limit it just to the pandemic, just to treatments for COVID-19. So it'll be probably temporarily limited and limited in scope in terms of at least the nature of the IP in terms of what it covers, just treatments for COVID, such as vaccines, like Pfizer and Moderna's mRNA vaccine and J&J's standard vaccine and things of that sort.
Okay. I mean, I guess we'll have to wait and see more about how the details of this unfold, but I don't think that should stop us from forming a view of what's been proposed. So can you tell us more about your basic view of this overall proposal, and maybe add to that a little bit about your overall view of the importance of intellectual property rights as well?
Great. Yes, those are great questions, because the specific details of what happens with this proposal and the exact nature of how the waiver is framed and is approved by the WTO in the fall, those are minor detail points, because the reality is that this is unprecedented, which is true. The U.S. has never supported a wholesale waiver of intellectual property protection like this before, and it's a disaster. And it's completely false. It was driven by false claims about intellectual property allegedly blockading or stifling the development and distribution of vaccines and drugs, and it completely undermines the whole function of intellectual property in providing reliable and effective protections to innovators and creators who engage in massive amounts of labor over many, many years to create through rationally guided, productive activities, these incredible life-saving technologies. So I just want to be very clear and adamant about this from the get-go. There is zero evidence, that patents or any intellectual property right has blockaded or stifled the development or distribution of any vaccines or drugs. In fact, the evidence is all to the contrary. It was, in fact, I have to say was, because it was the reliable and effective patent rights that have been provided for decades to all of the innovators in what we now call the biotech revolution, which the United States took the lead on starting in 1980, while the rest of the world waited and thought, this is kind of a uncertain area, and this involves genetically modifying organisms, and we don't know if this is right. The United States said, no, this is exactly what patents are supposed to protect. This is innovation. This is the creation of new values that make possible thriving, flourishing human life. And we said, certainly we will protect this. And this is exactly why the biotech revolution occurred in the United States and has given us incredible, I use the word miraculous, developments in the past several decades. I mean, conditions that were death sentences, even 20 years ago, diabetes, hepatitis, many forms of cancer, are now completely manageable day-to-day conditions thanks to the biotech revolution and the incredible drugs and treatments that has made possible. And this pandemic has proven that again and again and again. I don't know if people know the details, but we all have heard, or perhaps some of you have heard, that Moderna invented its mRNA vaccine in 2 days. A lot of people don't realize that BioNTech, which is the company that partnered with Pfizer, BioNTech was the one that actually invented the vaccine. It used its mRNA technology to invent its vaccine in 2 hours. And so the Federal Drug Administration, the FDA, had vaccines in February of 2020. I mean, so the 1 year delay, which itself is unprecedented, a 1 year development of multiple vaccines to treat a novel virus that's causing a worldwide pandemic, that 1 year delay was entirely the result of federal regulatory blockades at the FDA in not permitting these vaccines and drugs to be distributed to people in the healthcare market. And their ability, the mRNA technology itself was produced by innovators investing billions of dollars and thousands of labor hours over decades to create this new technology. And it's an incredible cutting edge technology. And to pull out the rug from innovators like this to say, yes, you can create, you can invest, you can develop something, this pinnacle of human rational achievement. And by saying, but then the moment there's an emergency, there's a need of someone in the world to get this drug or vaccine, and there's some reason that we can concoct that they're not getting it, we will take away your rights. That just will destroy the whole function and reason why we have an IP system or any reliable system run by the rule of law that secures property rights to people.
So you mentioned in your answer that one of the reasons that we have this system of intellectual property rights is to reward innovation. With that in mind, can you say a little more about what you would expect the most realistic consequences of waiving these rights will be? It's a little hard to imagine that, I guess, all innovation would come to an end, but there's got to be some kind of consequence here. So how would you try to, and I know it's hard to prognosticate, especially because we don't know exactly the form the policy is going to take, but what do you think is the most likely result?
Yeah, so I'd like to talk about the result, but I do want to talk about one other issue, which is related to my point about how there's zero evidence that patents have been a blockade. But people have been hearing how people have not been getting access to vaccines and other drugs. So what is causing the blockade? What is causing the problems? And as I mentioned, it's not intellectual property. It's manufacturing capabilities. It's having a distribution infrastructure. So refrigeration capabilities and roads to reach people in communities way out in the rural areas in India and other developing countries, and it's having a skilled workforce. I mean, the mRNA technology is cutting edge technology. It is extremely difficult to figure out how to use, and to mass produce a vaccine from this, which involves elements I think from like 60 different countries in terms of its raw materials, and the high-end technology needed and the skill set needed to then mass produce it at a quality level that leads to an efficacious vaccine. And I'm not talking about the 50% efficacious level of the vaccine of China. I'm talking about like the 95% level that we're expecting and we have from Moderna and Pfizer. That's really the difficult issue. And so this is what this waiver is really about at the end of the day. And there was a bait and switch. The moment the waiver was approved, all of the advocates for it said, oh yeah, you're right. It's really not about patents because patents haven't been a problem. It's about technical know-how and trade secrets. And so ultimately, this is going to be what we call in the innovation space tech transfer. Which is the transfer of knowledge and technology from one group or organization or jurisdiction to another. And so what ultimately, to the extent that this waiver, if it's going to have any meaning, it's going to have to mandate through coercive threat of law that we transfer that Moderna and Pfizer and other companies transfer their trade secrets and skills to China, Russia, India, essentially any country that demands it. Because that's the problem in those countries, is that they need to set up their manufacturing facilities, and they can't. The patents aren't going to help them set up those manufacturing facilities. It's our know-how. And so we are going to tell our innovators, you've invested all this time, you created all this incredible, valuable knowledge, technical knowledge that is yours under standard legal protections, under long-standing expectations of all creators and innovators. In fact, this was one of the United States' greatest contributions to intellectual property, was that we protected intellectual property as a property right. And that doesn't matter. The moment there's a so-called emergency somewhere in the world or in some place, we will actually take that away from you coercively. And it's not going to stop with COVID. So AOC tweeted the day of the announcement by Ambassador Tai, let's do insulin next. Because high prices are allegedly preventing people from getting insulin. By the way, it has nothing to do with patents either. It's totally parallel to the COVID waiver. Patents have all expired on insulin. So that, again, the blockade in insulin is FDA regulatory blockades. But it doesn't matter. They're using this as an excuse to attack intellectual property. And so this course transfer, that's going to have a real impact on people, as well as the undermining of the stability and predictability of patent rights more generally. And so the message we're sending to them is, hey, yes, invest billions of dollars. It's the most recent study shows that each successful drug that is sold in the marketplace, that first pill that is taken by a patient, started as 10,000 molecules that were originally investigated and researched for potential activity against the illness that pill is now treating, and represents up to 10 to 15 years of research and development and more than $2.6 billion. No one will engage in that if they are told, yes, and you have a mere privilege, a mere kind of paper right that we will choose to restructure and take away from you at any moment that we deem. That's not a system of rule of law, and that's certainly not what we mean when we protect the rights of life, liberty, and property.
So it sounds like you're saying there are two really important factors here. One is that we're not even just talking about the waiver of a patent. We're also talking about this forced tech transfer, which means that the penalty is even bigger than you might imagine. But then there's also the factor of the amount of work that goes into developing these drugs in the first place. So the bigger the penalty and the amount of work that it takes to actually produce it, the less incentive overall to engage in all of that work. Is that a fair summary?
Yes. I mean, and we all understand this point already implicitly before we even learn about intellectual property, because this is a lesson that we know about farmers and the green revolution that occurred in the 20th century that prompted by genetic modification of wheat and things of that sort. What farmer will spend a year, because it's a year, right, tilling the soil, planting the seeds, weeding, spraying pesticides, killing, then harvesting the crops, and then collecting them, taking them to the mill. It's a lot of labor before they've sold a single fruit of their labors, as the famous metaphor is framed. When no farmer will say, yeah, I'm going to do that if I am not secured the fruit of my labors. And this is why this is a really powerful, long-standing metaphor in property law generally. And John Locke uses it, that the point of property is to secure to people the fruits of their productive labors. And this is exactly what patents do. And when you don't secure to people the fruits of their productive labors, then the creations of their rational mind, then they don't produce, and they won't produce, and they shouldn't produce, because then they're being treated as a metaphorical slave, or literally a slave for other people.
And just to clarify one point of fact, you've stressed how much work it goes into developing these innovations. You also said that it took only a couple of days to create the mRNA vaccines, but that's because they had spent decades developing the mRNA technology, generally speaking, which the very specific virus could then get plugged into. Is that correct?
Yes, I mean, and that's what I was mentioning. I was referring to earlier when I said that the response to the COVID-19 pandemic, which, as I want to stress again, is historically unprecedented. COVID-19 is not going to be a repeat of the 1917-1918 Spanish flu, when an estimated 50 million people died around the world, when the world population was just 15% of what it is today. And that's because of the responses of companies like Pfizer and BioNTech and Moderna and J&J and Gilead and all the others. And because what they had at hand already in January of 2020 was a massive infrastructure that they had spent billions of dollars creating over the past several decades through their productive labor and investments, in terms of developing the technical know-how, learning about DNA and then RNA, developing the infrastructure, the scientific infrastructure, but not just that, the commercial infrastructure. So the agreements and information sharing agreements between all of the different companies is incredibly complex. The amount of commercial agreements and sharing of information between companies. The example of this is BioNTech partnered with Pfizer, because BioNTech actually came up with the innovation, but they didn't have the manufacturing capabilities or the distribution capabilities, so they couldn't scale production, so they entered into a commercial agreement. But commercial agreements are only possible if you have property rights, if you have effective property rights. The subject matter of any agreement, of any contract, is property. And so this is what facilitated all of this, was the patent system and the security of patents in all of these biotech innovations of the past several decades. So this is what led to this explosive response. The Biotech Innovation Organization has a COVID-19 tracker for tracking the amount of actual molecules and drugs and other therapeutic treatments that are being researched. And in May of 2020, it was something like 450 active treatments for COVID-19 were currently under research or development. And by September, it was 760. I mean, that has never occurred. And that was all made possible by this foundation, this launching pad that was built by the patent system. And I want to emphasize, too, that, as you mentioned, the mRNA technology was produced and created through 2 decades of work by the founders of people at BioNTech and at Moderna, who did this on the basis of their own money and their own effort. It was not created by the government. And there was, and except for a very teeny tiny amount of money provided to Moderna by the Department of Defense, it was almost all entirely through private funding.
And I want to come back to the issue of government funding shortly, because especially we're getting some questions about that already. But yeah, to do that, I want to actually ask you a few kind of devil's advocate questions. I've read now a number of articles by people who advocate these waivers. And I've made a list of what I think are the more persuasive sorts of arguments that they are giving in favor of them. And so start with the issue of innovation incentivization, which you've suggested is one of the major reasons we have intellectual property rights. When you argue that, I think the critics will say, or the other side will say, aren't you, in effect, justifying patents and copyrights and other forms of intellectual property on the basis of sort of the economic benefits they have on the public, on the public good, the common welfare? But then if that's the case, if that's their justification, when you have a situation where, let's say, there's a very large number of people around the world who are in desperate need of this vaccine, doesn't the public welfare, the common good, demand at least the temporary restriction of these patents, if the whole reason to give them in the first place was public benefit?
Yeah, these are great questions, and they really are legitimate confusions, especially given the prevalence of the arguments that one sees in newspapers and in the policy debates, and even even the legal literature. So first of all, just because one argues that something is right, that leads to good consequences, doesn't mean that you are engaging in a necessarily utilitarian or, in a more philosophical framework, consequentialist argument as such. One of the keys to understanding whether something is right, whether it accords with the facts of nature and whether it's consistent with the requirements of a flourishing human life, is that it works, that it makes it possible for you to flourish and to succeed. The founders of our country, even John Locke, who animated them and inspired them, understood this. This is why they said in the Declaration of Independence, right, that it's the purpose of government to protect the rights to life, liberty, and the pursuit of happiness. Now, if one takes the point that you just made all the way to its logical conclusion, one would have to conclude, well, the founders were basically utilitarians because they said the whole point is the pursuit of happiness. But no, what they're saying is it's the protection of rights and, of course, the right to life, liberty, and property, which is what makes possible people to have the freedom and the capability then to pursue happy, flourishing lives, and people being happy and flourishing themselves in a system of limited government and run by the rule of law, then makes possible society to flourish more generally, because everyone that makes up society is flourishing and happy. And by the way, they applied this exact framework to intellectual property, to the patents and copyrights that they authorized Congress to secure in the US Constitution, which itself was unprecedented. Never before in human history had a founding document authorize the government to protect patents and copyrights. And in fact, I always like to point out, as an aside, it's the only place in the Constitution proper, so the Constitution that was written in 1787, pre-Bill of Rights, where one finds the word right even used, where Congress is authorized to secure the exclusive right to authors and inventors to their respective writings and discoveries. And so they understood that this was a fundamental property right that had to be protected because it's what drove so many other property rights. In fact, it's what makes property possible, is the kind of the, and this is Ayn Rand's even much more explicit insight, because their understanding was not explicit as this. They kind of implicitly got it, that it's the rational mind, which actually is what is the driver and creator of all values. And it's the rational mind that is ultimately it's the products of the rational mind that are being secured by intellectual property. So it's not a purely consequentialist or so-called utilitarian argument when one says the reason for why we have these protections is because this is what makes possible people to produce in the first place. Is exactly why you want protections of rights, is because it makes possible flourishing, happy lives. Now, you also asked an additional question. Well, yeah, but then what about emergencies? Well, emergencies are situations where then rights become impossible to recognize and enforce. A true emergency is a situation where there's a massive war or something of this sort, and things of this sort. I wouldn't classify what has happened with COVID-19 as a quote emergency unquote, or at least an emergency in the context of we have to set aside rights and protections to accord with this. I think that it raises important fundamental questions about scopes of legal liability and scope of legal liability between individuals as to infections and things of this sort. But this is exactly what our system is designed to accommodate and to address. And at the end of the day, emergencies are always the excuse. Everything is being always framed as an emergency. I mean, I mentioned it earlier, Rahm Emanuel's infamous statement, you never let a crisis go to waste. And as AOC said, let's do insulin next, because those are emergencies to these people. And if that's your baseline, emergencies, which creates needs of other people, which then created a basis for disrespecting individual rights, then individual rights are no longer a principle that we're acknowledging. The principle is need. And then it just becomes fighting over the few scraps that remain and that producers will no longer produce.
Okay, so second devil's advocate question, following up on that one. I get the point that you're making, that this is a fundamentally moral perspective related to individual rights. The economic factors are maybe a secondary aspect of that equation. But then if it really is an individual rights perspective that you're bringing to bear here, wouldn't the individual rights perspective say that if you're going to secure a property right, it's got to be property that you have rightfully acquired through your own means? And this is then, I think, where the question someone on Zoom asked is relevant. On Zoom, they asked, when companies or investigators accept federal support through the NIH or the NSF, doesn't the government retain the rights to all intellectual property and inventions? And I take it the idea here is, well, yes, if they had to develop these drugs entirely through their own means without any kind of government assistance, then they'd have the right to secure their patents entirely. But since that's not the case, what are we to think of it?
That's an excellent question, and one hears that all the time. Everyone responds to me on Twitter by saying, "Oh, well, the government created this, the government funded it, so they don't have a right to it at all." It's a very, very common, prevalent claim, and there's a widespread confusion about this. It's both, and it's very important to get clear on the facts, because there's a lot of factual misunderstandings, and to get clear on the moral principle of the matter. I'll start with the facts. So as a preliminary matter, as I mentioned, there was no government support provided to BioNTech and Pfizer in creating their vaccine. Operation Warp Speed that the government adopted represented advanced purchase agreements by the federal government. Federal government saying, if this is approved by the FDA, we'll buy this. By the way, the federal government didn't give them any choice, because the federal government said, we're going to control this. So if you want to distribute your vaccine, we have to buy it. I mean, that was their only choice. Or two, it assisted them with setting up some of the distribution and manufacturing capabilities, so that they could hit the ground running when the FDA finally authorized the use of the vaccines 10 months later. The actual creation of the vaccine itself was not done with government money. And I mean, and I have to emphasize that because there's a lot of claims about that. Oh, the US government created mRNA technology. No, it didn't. It didn't at all. In fact, it was so cutting edge in the 1990s. The person who did create it, the doctor who's the founder at BioNTech, she was actually applying for public grants because they all apply for public grants. And she kept getting denied because she was being told, you're insane. This is impossible. This can't happen. And she just said, all right, well, I believe in this. This is true. And I'm going to pursue it. And she ended up getting private funding to develop it. And so, so it's second of all, it's not true that if the government provides some funding, the government owns it. That's not the law. The law is regardless of whether the government provides some funding, regardless of how much, then the government has certain rights to license the technology under very certain narrow conditions. And the conditions are that the technology or product, the patented product, is not being deployed commercially at all. That's essentially what the requirement is. This is a law called the Bayh-Dole Act. The Bayh-Dole Act actually was enacted by Congress in 1980 because of the exact problem of government funding. The government had been funding so much research since World War II. There were questions about who owned this, and people weren't getting patents. And Congress heard testimony that there were literally new inventions that were sitting in labs that no one would touch. Incredible medical cures and discoveries because the ownership status, the property right status in these inventions was unclear given the government funding for it at some point or other in the process. And because you need property rights to enter into commercial agreements and to create the value chain to manufacture, produce, and distribute these things. And so the government enacted the Bayh-Dole Act. The whole purpose of the Bayh-Dole Act is to say, if you're the researcher, you're the one who engaged in the inventive labors. It doesn't matter if at some point or other you got 1 cent of federal funding, you can get a patent. So the actual rule is the exact opposite. The creator, the inventor of a product or service gets the patent, has the property right in it, because they created it. And then if you sit on it and don't do anything with it. So for instance, there's no one getting any vaccines, or there's no one getting remdesivir or any other drug treatments, then the government can step in and license that patent without your authorization to other people to manufacture it. But clearly people are getting vaccines, and clearly people are getting drugs and other types of things. And so this is called the march-in right, or the march-in power of the Bayh-Dole Act, and it's never been used because products are commercialized. Third is, I really want to hit back on the whole premise also that the government just funds all research, and it doesn't. The government funds, actually, relatively speaking, a small amount of what is actually very far upstream research. So to give you a sense, total private sector funding of biomedical research in 2018, which is the last year we have the data for, was approximately $140 billion. And that's sunk cost. That's research that they spent before they saw a dime on it. That same year, NIH, which is the largest funding public entity in the country, or in the world actually, provided $30 billion in research. So you have a 4-to-1 or 3-to-1 ratio there. Now, most of that research money, though, from the NIH, as I mentioned, goes to upstream, very far upstream basic research. Remember I mentioned that, for every pill that's provided to a patient, that represents 10,000 molecules that were originally investigated. That's where that money is going to. The money is not going to the actual development of the pill itself. That pill actually is the byproduct of massive amounts of funding. And it's just, so the actual reality is that most of our ongoing medical innovations in our country and in the world more generally are driven by and are supported by private funding, not public funding, despite the claim to the contrary. Now, one could still say, yeah, but there's still some public funding, right? So you can. So what about that public funding? Well, this is the problem. This is the problem with and then raises the moral principle. This is the problem with government funding more generally of anything. Because this is the principle was invoked by President Obama when he said, "You didn't build that." when he was talking about entrepreneurs and business persons. Now, he literally wasn't saying, if you actually go back and read the full quote that, what he says after he said that infamous sentence, he doesn't say, you didn't build your business. What he says is, you didn't build the roads. You didn't pay the teachers. You didn't create the public universities that made it possible for you to have a successful business. And so he was making a fundamental claim that because the government actually does all of these things, then the government ultimately, the society more generally in his mind, his collectivist conception, actually has this claim to actually what the individual creator innovator did. And that is I lack the term for it properly. It is a moral crime to denigrate the innovative, creative labors of these researchers who create things like mRNA technologies, or who create all of these other incredible things, because the government has not made it possible for them to live and work in an environment where there's only private funding of research, where the government funds so much of the basic research and the universities that you can't actually have a job anymore unless you apply for some government funding along with all your other grants that you receive from private funding sources.
If I take my devil's advocate cap off for a moment, I would mention that it's really relevant. It seems that the government, the existing structure of government funding, often makes alternatives impossible. You mentioned a while ago that the pharmaceutical companies who developed the COVID vaccine weren't even given the option of selling this on the market, that the government told them in advance, we're not going to let you do it. And which basically means the only way that they can get funding for this is if they take the government payments for the purchases. It's really kind of, they're making them an offer they can't refuse, quite literally. Yeah. The same point would apply to all kinds of other things in life. If we drive on public roads, does this mean now we don't really get to own our cars? We don't get to have property rights in our cars or in any of the businesses that we create using an automobile? This argument would completely negate the basis for any kind of property rights throughout the economy.
And
but to put my hat back on.
And it's used for that purpose. I want to emphasize that again, because why stop at direct government funding? Like President Obama said, right? You didn't fund the public university professors who taught you. And that's true. Or the public school teachers. So, heck, if there's no difference in principle between learning, all of your biochemistry knowledge from someone who works at a public university, then the NIH providing you a small grant at some point during your research activities.
So put my devil's advocate hat back on. You mentioned the Bayh-Dole Act, which you observed was created specifically to identify the patent rights that innovators have, even in the face of government funding. But if we're going to go by the rules here, if we're going to look at the actual laws on the books, another point that advocates of these waivers will make is to invoke a fairly obscure section of the U.S. Code, Section 1498, which supposedly gives the government the right to use a kind of eminent domain for patents when technology is funded by government money. Doesn't that mean that government still, in spite of what you're saying, at least has the legal right to commandeer these patents under the present circumstances? What about Section 1498?
Yeah, Section 1498. So it needs a spiffy name like Idol or something. It's so the government. One of the unfortunate mistakes of the founders of natural rights theorists more generally who inspired them was this belief that that you in part transfer your rights to the government when you enter into society. And so governments have this power that they called the eminent domain. It was a phrase coined by a natural rights philosopher, Hugo Grotius, to take property. And so it's in our Constitution, in the Fifth Amendment, the government, nor shall private property be taken for public use without just compensation. So the idea is that, well, the government has this power, but at least should pay you when it exercises this power. So you get something for your labors when you have your rights violated by the government. And Section 1498 the statutory section that authorizes people to sue the government, patent owners. I'm sorry, Section 49 is the section that allows patent owners to sue the government when the government exercises its sovereign domain power, and so that they can receive appropriate. The term in the statute is reasonable and entire compensation. So Section 1498, though, is not a price control statute, and it's not a statute for the purposes of directly interfering or engaging with the market. Now, the U.S. federal government has passed those laws all the time. In 1942, they passed a price control law called the Price Control Act of 1942. States have adopted rate regulation statutes under their so-called police powers for regulating the rates that railroads charge and things of this sort. There is no reference in the statute whatsoever to rates, prices, or anything. It's about the government taking a patent for use by the government. The examples of the cases from the 19th century were examples of the U.S. Army. One very famous case involved the U.S. Army using a patented tent without approval during the Civil War. Another was a patented cartridge box, a bullet box that could be where soldiers could carry bullets on them. Another involved the U.S. Postmaster. And so Section 1498 does not authorize the government to say, I'm taking your patent from you for the purposes of giving it to another company to sell in competition with you to private consumers in the private healthcare market. That's not what Section 1498 authorizes, and it's never been recognized to authorize anything like that, except by academics. There's a bunch of law professors who've written some articles saying, "Oh, this is actually a price control statute," and it's not that. Now, there shouldn't be an eminent domain power in government. Ideally, there shouldn't be we shouldn't have a takings clause. Should be unnecessary in a proper moral government that really truly respects all individuals' rights to life, liberty, and property. But when we do, you have to respect the terms of the takings clause and the terms of the statutes that effectuate the takings clause. And the takings clause is not a price control statute or a price control provision in the Constitution either.
And I should mention, I read the section of the law in question, and the first thing that stood out to me was that it was primarily about who gets to be sued. And so even this section, isn't it primarily saying the person who gets sued when the government expropriates a patent is the government? But that doesn't mean that you can't sue them, right? Yeah.
So this is the problem. It's a general problem in all law. Governments have also what's called sovereign immunity. And so you can't sue the government unless there's a statute that authorizes you to sue them. This includes under every provision of the Constitution. And so, for instance, when people sue the government for violations of their rights under the Due Process Clause or under the 14th Amendment, you hear about these lawsuits all the time. They're actually done through federal statutes, and the lawyers refer to them as Section 1984 or Section 1988 cases, because those are actually the statutes that authorize someone to sue the government for a violation of their rights under those particular constitutional provisions. And Section 1498 is the statute that authorizes someone to be able to sue the government in its own courts to seek remuneration for when the government takes and uses a patent for the government's purposes, not for someone else's purposes.
Right. So I want to ask one last devil's advocate question.
Yeah.
And this one cuts to the core, I think, of the moral controversy here, and it relates to something that someone was asking on YouTube. But isn't this a case where basically property rights are being used to allow big companies to profit from the spread of a disease? And isn't that just awful?
I'm sorry, I'm laughing because I'm tempted to be kind of controversial and say we want them to profit, because when a company profiting is a company succeeding. And what does it mean for a pharmaceutical company to succeed? It means that they actually are creating massive amounts of important life-saving drugs that they are selling in the marketplace and for which everyone around the world is benefiting from. and then to say, well, how dare you create this incredible technology that makes it possible for me to live my life, because you should have what? Given it away for free? Never produced it in the first place? The norm, people forget how incredible our lives are today. The revolution that was wrought, not just by the biotech revolution, which I've been emphasizing, but the whole pharmaceutical revolution is less than 100 years old. I mean, this is so we've really forgotten what life was like before the early discovery of antibiotics in the late 1920s. Just to give you one example that I like to highlight. So in 1924, so this is less than 100 years ago, President Calvin Coolidge's 16-year-old son died because he was playing tennis on the front lawn of the White House, and he injured his little toe, and he got a staph infection, and he died in a week. He was dead in a week, the president's son, because the antibiotics that are now cheap and prescribed daily and no one thinks twice about taking today, right, hadn't been discovered yet and hadn't been sold, and companies had profited from by selling to invest in and create and continue to engage in creating incredible new products that drove incredible new innovations and healthcare. And so, I mean, this, as I said, this is less than 100 years ago. And patents have been intimately connected with not just the creation of or the discovery of these things, because humans can invent, and humans have been inventing for millennia. The problem isn't incentivizing people to invent. People are naturally invented, so to speak. This is what it means to be a human. The problem is, how do you turn an invention actually into an actual product or service that other people can use and can exchange with the inventor or other people such that it benefits their lives? In other words, how do you bridge the gap, is the phrase, from the lab or the garage to the marketplace? And the only way you bridge that gap is property rights. Nothing else does it, because there's nothing else that does it. Prizes are not property rights. So, because it just falls into the public domain. And then who invests all of the money, the billions of dollars, to create the infrastructure necessary to engage in commercial exchanges, agreements, manufacturing, distribution, retail, and ultimate distribution to consumers? This is the United States' key contribution. We were the first country that took seriously the idea, starting with our very first patent law enacted in 1790, that patents were property rights. And this was key and fundamental to the United States converting within a matter of decades from being primarily an agrarian society to being an advanced industrial country that was challenging England for economic dominance on the world stage because of the innovations created by Isaac Singer and the sewing machine, and Samuel Morse with the telegraph, and Samuel Colt with the repeating firearm, and Cyrus McCormick with the first mechanized reaper, the harvesting crop, and Eli Whitney's cotton gin. And the issue wasn't that, they were, that they invented it, is that these inventions were converted into real world commercial products. And that was only made possible by recognizing property rights and the ability to use and dispose as secured to you under the law. And this has been fundamental not just to our industrial revolution in the 19th century, but as I mentioned, the pharmaceutical revolution of the 20th and the biotech revolution of the 21st century.
So I'm going to take my devil's advocate hat off completely here, and just to say one thing, especially about that earlier question about profiting off of disease, because I think it's on this kind of question, it's also important that the kind of direct answer to that is that they're not profiting off the disease, they're profiting off of curing the disease or stopping the spread of the disease,
better way to frame it.
In the case of a vaccine. And that's a really important difference. And I think that what you just explained illustrates why that's true. I really like the way you're framing it. I want to ask you one more question, and then we should take a look at some questions that have come in. So you emphasized at the top of our conversation how it's not the patents that are to blame for the production and distribution problems. You mentioned supply chain bottlenecks, et cetera. But Are there any aspects of the supply chain bottleneck production problems that could be remedied through perhaps other changes to the legal system, to our trade policy, if we're concerned at all with allowing people in other countries to get the vaccines that they need to survive? What are some measures that the United States could take that wouldn't involve this gross violation of property rights that the Biden administration is now proposing?
Oh, perfect question. And, and right off the bat, because there are numerous things that we could do that would immediately alleviate and the impact of this pandemic on people around the world. And the first thing is, there is currently trade embargoes that limit the ability to transfer vaccines from various countries to other countries. The United States right now legally prohibits exporting vaccines from the United States to other countries. And we are sitting on a massive stockpile of the AstraZeneca vaccine, which we're not using, given some concerns about its total efficacy, because it has some efficacy, just that the FDA said that's not good enough. So we're not going to allow that to be used in the United States. Well, look, if you're, 70 or 80% efficacy is pretty good if you're facing, death, which is what they're facing around the world at the moment in India and other places. And we should immediately allow these vaccines to be, be exported to those countries, which, by the way, then they're going to sit in a bunch of warehouses and probably not get actually to the people who need them because of all of the underlying infrastructure and distribution problems that you have in those countries. But nonetheless, they might get to some people, and that would help some people. The other thing is remove all of the regulatory bottlenecks on the actual approval and release of these vaccines. As I mentioned at the very start of our discussion, these vaccines the mRNA vaccines were available over a year ago. It wasn't the companies that sat on this. It was the FDA that prohibited their distribution. And by the way, it's the FDA in other countries, their equivalent of it, that is prohibiting the distribution of vaccines in those countries. The CEO of Pfizer released a letter shortly after the announcement by Ambassador Tai, saying, look, I personally called up leaders of various countries to say to them, I want to offer you our vaccine. And they said, your vaccine is new and untested. We don't trust the mRNA vaccine, so we're not going to approve it in our country. What can you do? You're not, at that point, the company is not to blame, and we shouldn't be blaming the companies. We shouldn't be punishing the companies. We should be punishing the politicians and the regulators and the statists that are preventing people from getting access to life-saving drugs that could, and other types of treatments that they need or could use and benefit from.
It's interesting that we talked about Section 1498, and there was an article, I think, that you showed me from the New York Times that was published maybe sometime last year, and it was arguing that if we don't invoke Section 1498, we're never going to get even enough vaccines for the United States, let alone for the rest of the world. And yet, here we are, sitting basically on a vaccine surplus. And that's in spite of the fact that these companies weren't able to sell their vaccines on a true free market. I mean, imagine if they had been able to, how much more they would have been able to increase their productive capacity, how much even bigger of a surplus they'd have right now because of that. And then if they were allowed to actually export them to other countries, how many they'd be selling overseas. So it's truly staggering to consider. Well, maybe if the argument didn't work for the U.S., it won't work for the international scene either. We should take a look at some of the questions that have come in. I see at least a couple that I think are pretty good, and I'd like to hear your thoughts on. We got an early question on YouTube. Someone asked, how can you call products of biology intellectual property? What's the alternative for someone wanting to produce a vaccine? How can they compete if there is a single solution type? Now, the part of the question I think was more interesting is how can a product of biology be considered intellectual property? And I can see why a person would want to ask that question. In what sense is this a product of biology, for instance?
Mm-hmm. That's a really great question. And it's why the rest of the world paused and hesitated 40 years ago when the biotech revolution was just starting with very small startup companies like Genentech, which actually got started on a patent on the ability to create synthetic insulin, which has now there are millions of people who are alive today with diabetes because of cheap access to insulin because of that biotech innovation. But the other countries said, this is messing with biological materials and molecules, and this is not something that should be patented. And it is a rule actually in patent law. You can't patent basic facts of nature. So you can't patent a rock on the ground, or you can't get a patent on the formula E equals MC squared. These are laws of nature and facts of nature. What you get patents on are values that are created by humans. And notice here, they're not getting a patent on just a piece of DNA. That's how it's framed off in your DNA patents. It's not the case. What you're getting a patent on is the biological material, the molecule, the RNA strand or the synthetic RNA strand that is being used in a medical context to create a vaccine, or to create insulin to treat people with diabetes, or to create some other type of drug to treat people with AIDS or something of this sort. At that point, it is no longer purely just a biological fact of the world. It is a human value. It's the difference between, a plant and a crop. You could say the same thing about crops. Crops are those are plants. How could we have property rights in them? Because we take some plants and we turn them into human values. We turn them into things that through the human rational mind, we figure out this actually supports us. Like we want to figure out ways to support, to create it, to grow it, to make more of it so more of us can live. And if you come up with a new method of harvesting wheat, you can get a patent on it. Cyrus McCormick did on his mechanized reaper. Or the Green Revolution in the 1950s, where they figured out ways to genetically modify wheat so that more wheat would be produced. These are human created values, and all values that are created are rightly and justly the property rights of the people who create those values, and intellectual property represents that par excellence.
Yeah, and you've also got to know a little something about the biological product in question here, and what you needed to do to actually produce this biological product to see that there is an issue of creation here. So it's not the case that mRNA vaccines are in effect growing on trees and you just pluck them off the tree. I mean, there's mRNA out there in nature, but it was an incredibly sophisticated scientific achievement to isolate which aspect of that molecule is relevant to creating a kind of immunity. Nobody thought it could be done. As you mentioned, it was treated with extreme skepticism. And then, of course, you had to isolate the genetic code of the COVID virus to be able to transfigure that into a vaccine. And on top of that, there are all kinds of other technical hurdles, like when you take just pure mRNA and inject it into a human body, it typically creates a kind of autoimmune response. And so they had to create a special kind of lipid packaging that would allow it to go into the body without creating this autoimmune response. And then that took a lot of testing. So this is no trivial plucking of a fruit off a tree. This is an incredible act of bioengineering. So it's an invention more than it is a discovery.
Although don't imply that plucking fruits off trees is not an active invention either, because you have to know which fruits to pluck and which ones, what are the right ones and what are the false ones. I mean, that at one time was an active invention itself. And what you're describing, Ben, which is exactly right, and very well stated and summarized, is true, by the way, of all medical treatments. First of all drugs are at the end of the day a molecule that they discovered is active against an antigen, an invasion of your body. But if you think about what goes into why it's $2.6 billion, why they investigate 10,000 molecules, because it's not just discovering the molecule, it's then figuring out how to get past the hydrochloric acid in your stomach, how to get it absorbed through the intestinal wall, how to get it into your blood system such that it's not attacked by your immune system. This is, I mean, it's incredibly complex when you think about the achievement of what goes into a pill that you pop in your mouth without thinking twice about it, whether it's ibuprofen or whether it's, well, they're going to have a pill for us to take for the vaccine for COVID by the end of the year.
So related to that, here's another question that came in through Zoom. Someone asks, most recently, a vaccine was discovered for malaria. Do you know how intellectual property rights have played a role in this medical innovation? And correct me if I'm wrong, Adam, but I believe the person is possibly thinking of yet another mRNA vaccine that's being worked on in relation to malaria. Is that correct?
Yes. mRNA technology is the promise that we all have been waiting for from the biotech revolution. When they mapped the human genome in the 1990s, and they mistakenly thought that there was a really easy, basically one-to-one correlation between particular gene sequences and diseases, and they discovered it's much more complex than that. So they thought oh, we're going to have cures for cancer and all sorts of things very quickly, and we haven't. And it's mRNA, this technological platform. In fact, mRNA is referred to as a platform technology for precisely these reasons. And right, it's not that they've discovered a vaccine; they're now developing, using the mRNA platform, vaccines for malaria and a vaccine for AIDS as the next two developments. Now, if this waiver goes through, which it most likely will, don't expect to see very many more of these being developed. Because the message that's being sent from, by the way, the country that has for 200 years been the leader of the entire world in the protection, recognizing the legitimate moral claim of innovators to the property rights in their creations. When we say no, we don't recognize this stuff anymore, given someone's need, someone's emergency, don't expect much more of these innovations potentially down the road, unfortunately. But right now, they are investigating these incredible innovations.
Yeah, I think that's really important to stress, especially because this isn't just about COVID. It's not just about malaria. It's not just about AIDS. One of the arguments that you made in your article for the Virginian Pilot is you have to take the long view here. And there will be more pandemics, probably within our lifetime. There certainly will be more diseases. There's already all kinds of diseases out there that we'd like to find vaccines for that exist already. And what mRNA has the potential to do is actually to produce vaccines for each and every one of them. And but that's only if there's an incentive on the part of the creators to do it. And it sounds a lot like what the Biden administration is interested in doing is literally killing the goose that has the potential to lay many, many golden eggs for us. And we may get, one golden egg as a consolation prize in the short term, but unjustly and at the expense of so much of the rest of our future.
Yeah.
So I want to thank you, Adam. I think we should start to wrap up. There's a few resources that we would like to share with our audience before we do that. So first of all, I want to let our audience know about an essay that Ayn Rand wrote on this subject that I think, Adam, you probably have in mind when you are commenting on patents as a kind of individual right. This is where Ayn Rand lays out her theory of how patents and copyrights are forms of individual rights. It's her essay, Patents and Copyrights. You can read it online for free, thanks to the copyright permission of the estate of Ayn Rand. If you go to bit.ly/patents and copyrights. That's at the Ayn Rand Institute's website. And then I'd also like to let our audience know about your article, Adam. This is Waiving Vaccine Patents Would Imperil Public Health. I created a short link for that one too, bit.ly/waiving patent rights imperils. That's the article you wrote a few weeks ago, about a month ago, I think, which was prophetic, predicting that this was going to be a big deal. And I know that you've been making this interview circuits for the last week because basically your unfortunate prophecy came true. So we'll refer everyone to that article. Also, just want to let people know what they can do. Oh, one more article, and this one's by me, actually. I wrote this article a few weeks ago, The Unscientific Un-American Ethics of Vaccine Distribution. And this speaks to one of the last topics that we were discussing, Adam, about the fact that the government decided from the beginning of the pandemic that it wasn't going to allow vaccines to be sold on a free market, that it was going to be basically centrally plan the purchasing and distribution of them. And this has resulted in a patchwork of double standards in who gets what first. I talk about some of the philosophic ideas behind the idea that government needed to be in control of this in this article. So if someone wants to learn more about that, go to bit.ly/unscientific vaccine ethics to learn more. I also want to let our audience know that we're going to be doing, for our next episode of New Ideal Live, a special episode. We usually do this once a week, but we're actually going to have 2 episodes this week because of recent events in the Middle East. On Friday, Elon Giorno, who's my colleague and the senior fellow at ARI, will be interviewed on the topic of the Israel-Hamas crisis. That'll be Friday, this coming May 14th at 12:30 p.m. Pacific, 3:30 Eastern. So stay tuned for that. If you are interested in following us, if you like this broadcast and you'd like to see more, if you're watching on YouTube, please be sure to subscribe to the ARI YouTube channel, hit that bell button to get notifications for when we post new materials or go live. Also consider liking this episode and commenting on it if you're watching the recording, because that's going to help the algorithm attract more attention to our YouTube channel. Same story if you're watching on Facebook. Please like this episode or write a comment. That also helps nudge up the episode in the algorithm's sensitivity. Last of all, if you have questions about what came up in today's episode, consider writing us an email at newideal@aynrand.org. We read everything that comes in. We respond to many of the questions. We also take suggestions for new topics that we might have future episodes on. And we also periodically have Q&A episodes where we answer some of the questions that have come in. So thanks again, Adam, very much. This was, I think, a very enlightening hour of conversation for our audience. We always appreciate it when you bring your expertise and your passion on this very important subject to the table.
Thank you. I think it was a lot of fun. I enjoyed chatting with you in particular about these issues a lot. So thanks, Ben.
You're welcome. So thanks, everyone. We will see you again this coming Friday. Until then, think rational thoughts about this and other issues. Bye-bye.